just wait a couple of minutes until everyone walks in. All right, good morning, everyone. Thank you so much for joining us. We are very glad to have with us today for our monthly webinar some very esteemed panelists, which I will introduce in a bit. But just before I do that, I just wanted to give a little bit of a background on the webinar and how the series started. I'm, as part of my job as the Global Climate Litigation Fellow at the Sabin Center, we created a global network of rapporteurs on climate litigation who are volunteers that assist us in keeping the database comprehensive and regularly updated, representing each jurisdiction. We created that last year in December, and we, as part of that exchange with them, we decided to create a monthly webinar series in which we could either focus on a jurisdiction or a case or some cross-cutting themes in climate litigation to keep talking about some of the topics that are recurring within this area. So we have held 2 webinars already, and I will include the link here if you want to see the recordings. And we are very excited to have this one today on national fair shares and in greenhouse gas mitigation impact for climate change litigation. So we have today Dennis van Merkel, who's the legal counsel to the Agenda Foundation in the Netherlands and co-founder and co-director of the Climate Litigation Network, Professor Lavanya Rajamani, who is a professor of international law at the University of Oxford, and Lucy Gray, who's a campaigner at ACID in Italy, so one of the cases that we'll be discussing here today. So without further ado, I'll lead to Dennis to start us off.
Thank you, Maria, and and thanks for organizing this webinar. I think fair shares is a very important topic, and it's at the core of what is really the front line or of where the climate litigation is against governments is kind of like being fought. This question of what is actually what governments need to do, what is the legal responsibility of a government with regards to how much it should be reduced, and that really all comes down to how you interpret a fair share and how can you argue that before a court. And I'm also very happy to be here together with Lavanya and Lucy. I think we have a very interesting panel here, and what I will do is get some give a bit of context and history to the discussion, and then hand it over to Lavanya and Lucy for very recent exciting developments and practice. So I will start, perhaps not surprisingly, the conversation on of fair share needs to start with your agenda judgment, not only because it was a well-known judgment, the first judgment on where a government was found to have responsibilities with regards to a legal obligation with regards to its emissions, but it's also the judgment where the debate on fair share thus far, it was for a long time the only judgment where it was really applied, and it's also still the judgment where it's most broadly discussed. So it's still, I think, a very important source to look at what is this whole discussion of fair share about. And I have some slides and pictures, because I usually don't do slides, but I think for this topic especially, this is pictures can help. So here we have in the agenda judgment, the court ordered the government to reduce its emissions by a minimum of 25% by 2020. Well, where did that come from? Originally, that number came from a range that was published by the IPCC in its AR4 report. That was the report published in 2007. And what was that number? And it's the numbers here in this table, according to the IPCC. In that report, developed countries needed to reduce their emissions by a minimum of 25 to 40% by 2020 compared to 1990 levels. And that range was derived. It wasn't just one model or one calculation that did that, but that was a range that was derived from basically the whole range of studies that was available at the time. They looked at all different studies and different interpretations of fair share, and they said, well, this is actually the range if you look at all those different interpretations. So it's a scientific range. It was and there was obviously then a lot of discussion in court on, well, this is just a scientific range. It doesn't mean that it is a legally binding norm. And there were many reasons in the end why the court found it to be legally binding on the Dutch state, including recognitions of the Dutch state itself of the importance of this particular range. But beyond that, it also said, well, yes, this is not legally binding in itself. It doesn't even offer very cut and dry answers. However, it does have meaning also as a scientific norm. And one of the reasons for that, and that's how the Advocate General to the Supreme Court, if you want to read more, very well thought through thoughts on fair share and the role of science and norms, this opinion by the Advocate General that preceded the judgment of the Supreme Court is really on every legal issue attached to the agenda judgment. It's really a gold mine of legal thinking, also on fair share. And it said, well, why is this important? Well, it's important because it's derived from the latest available scientific studies. And it's not just one interpretation of fair share. It actually covers the entire spectrum of parameters and assumptions. So it is a very well thought through assessment of basically of any way that you can think about this, and that's why it has importance. And no, that doesn't mean that it is legally binding as such, but it is a reasoned proposal, which also means that you have to have reasons as a government to deviate from this. You basically have to explain that if this is what science is telling us throughout on the whole spectrum of different interpretations, why would this not be the case? I mean, that's in simplified terms, basically what the Advocate General and then later on also the Supreme Court said. So that was, that was the agenda judgment, and what helped us very much in that judgment beyond this number of 25 to 40% being published by the IPCC is that it was also recognized in COP decisions. So in COP decisions, they referred to this boundary, and that didn't happen initially until very recently, again, in other COP decisions with regards to 2030, etc. I will get back to very recently because actually we do now have such a number or a similar number, which is not entirely fair share, but still relevant in the Glasgow climate Pact. So after agenda, the question was, okay, so this was 2020, we now need to look at 2030. So what is next? And then where lawyers looked at was again the IPCC, the new IPCC report then of 2013, 2014, and this was the way that they presented the fair share results. And it's not a very simple graph to read, but basically what it says is here are different ways. They didn't give one range, but they gave a number of ranges. And if you looked at and the problematic point from a lawyer's perspective is if you looked at the very upper level of that range and the very bottom level of the range, it was a very big range. So it told you very little. And there were also issues of, well, if everybody just picks their favorite, their favorite interpretations, we won't get anywhere. So that was a big challenge with regards to what was then at hand for lawyers with regards to what science produced. And on top of that, also, this was at the OECD level, as you can see on the very left of this graph. So that was also a challenge. Then following this publication by AR5, that hadn't been used as such, because it has actually only been used in one part of that report has only been used in one case thus far, and that's actually now the case from Switzerland before the European Court of Human Rights. But kind of like there was unfortunately a time where much less on fair share by scientists was produced, and that was, and I think if you have to find a reason for that, I think it was because the scientific community thought that, well, the Paris Agreement basically now says it's up to countries to decide what they want to do, and therefore this whole exercise of coming to a fair share division that can then be implemented through the governance, the global governance scheme, is no longer necessary. Luckily, there were groups, and Lavonia on this call was part of a very important group that picked this up, that said, well, actually it still has a lot of importance, and also in the context of climate litigation, but for a while there was very little. One paper that was available to litigators was this paper by Jean Roubiou-Dupont, and basically what he did is that he applied the division, the methodology that AR5 had produced to individual countries. And here you see one of the graphs, how he made this OECD level and translated it to an individual country. That was also presented to a court in a German farmer family case, but the court simply didn't accept it. And in short, what the court said, well, yes, this is a peer-reviewed paper, but it's only one paper. And this is not an assessment of the entire scientific literature out there, but it's one modeled interpretation of such an assessment. So it's too limited. And who am I to decide that this is the one way to actually do this? So that was not accepted by this court. And then in the same country, in the case that followed before the German German Constitutional Court, the Bundesverfassungsgericht, they again looked at this fair share question, and they were able to apply a certain interpretation of fair share. They also recognized the obligation of countries to do their common but differentiated responsibilities, which is by and large kind of like in general the main legal basis for having a scientific fair share division. And their basis for doing that was a report that was published by the German Advisory Council on the Environment, a very high regarded scientific advisory council. And what they did in short is that they looked at, and this is a couple of pictures that you see in this slide, they looked at the carbon budget, and they looked at the simplified carbon budget division. They said, well, we have a carbon budget, we need to divide that carbon budget as of the Paris Agreement, and that gives us a certain emission space. And then they applied that emission space. They took a 1.75 centigrade carbon budget. I think if the Constitutional Court would look at the case again now, they might actually get closer to a 1.5 budget to use, but at that time they thought that this was a reasonable interpretation of well below 2, and they said, well, actually current emissions are our current targets are actually go way beyond what the carbon budget that is available to Germany would allow, and that's kind of the green line. You see the red line, what's the target, and the green line was what the available budget would be. So I think they're two very interesting things to note here with regards to the application of the Bundesverfassungsgericht. One is that if you look at it purely from a scientific perspective, this simplified budget calculation has something. It has simplicity, but if you ask a real effort sharing scientists, sorry, Marie.
I think you're still showing the first slide, so you have
am
to.
I? Which slide am I showing?
The first one.
The very first one.
Yes.
That's very unfortunate because that's not clear in my screen. Sorry, people. So I'm talking about pictures, but nobody can see my pictures.
Now we can see, you're moving them.
Now you can?
Yes.
Oh, that's interesting. So I'll run everybody through this very fast. I was talking about ranges. That was this. So not very difficult to read and all about ranges. Jan Roubiou applied this in this graph, which had kind of like different interpretations per country. But again, the question was, which interpretation do you use? And then this is only one paper, basically. This is what I refer to with regards to the German Advisory Council on Environment. They explained the idea of a carbon budget and then applied it to German emissions as targeted. And the green line is the budget and the red line is what they were planning to emit. Sorry about that. So scientifically, it was a simplified way of explaining it, but it wasn't the most refined and scientifically thorough way of actually looking at the fair share analysis, as had, for instance, previously done by the IPCC on the basis of papers that had been produced by Nicolas Heune and others. But the main reason why the Constitutional Court was able to rely on this is because of the institution that produced the analysis, which was a very high regarded independent institution in Germany itself. And I think that that's also something, especially, and we can get back to that in questions and answers, looking forward and developments that we might want to see, is that engagement of that scientific body in Germany has had a very big impact in the context of that litigation. We have to be, that I think that's an important thing. So that's kind of like where the status was until the German Constitutional Court case, but that still leaves open these questions of what's the what is the real fair share, sort of the real fair share analysis you would see, and still in other countries that don't have these national assessments and couldn't immediately refer to the IPCC still had a big challenge. And well, this is the two. Those two areas is where Lavanya and Lucy will comment on. So I will leave you with one last thought, and that was in relation to what I referred to in the Glasgow Climate Pact, this number that has been taken up in that agreement. And what the agreement says basically is that, well, reaffirmed basically the need to stay under 1.5, and it acknowledged the scientific fact that that according to the IPCC, in order to stay under 1.5, emissions need to be reduced by 45% compared to 2010 levels, which is approximately halving emissions in the next decade. That's what it approximately comes down to. So again, why is this significant? We see this recognition of a scientific fact in such an important decision, which has unanimously been agreed to between the parties of the UNFCCC. And then the question is, why is it significant in the context of fair share? Because this in itself is not a fair share analysis. This is just a global average. Still, I think it can have importance in the context of the discussions with the courts with regards to, what should a country be doing and what is its fair share, because it, at the very least for global north countries, represents the very rock bottom of what any developed global north country would need to be doing. Because if you have a higher responsibility than a global south country, then at the very least you need to be doing the average of that, and to translate that into what does that mean in concrete terms. Well, for instance, the EU, which says that it has one of the most ambitious targets, has a reduction target of 55% by 2030 compared to 1990 levels. Just looking at the average and what they would be doing to follow this average line, they would need to reduce 65%, which is already a 10% gap. So I do think that this recognition is important, also for litigators in the context of this fair share agreement, but not the only thing that we need. And that's where I'm very happy to hand over to Lavanya, that has done great work in this area. I will now stop my screen share. I hope that worked.
Yes, it did. Thank you.
Okay, excellent.
So I'm going to pick up from where Dennis left off. What I'm going to, well, first of all, actually, I want to very much endorse what Dennis, the point that Dennis ended on, which is that the Glasgow Climate Pact endorsed the 1.5 degree temperature target, and that's hugely significant. It's hugely significant for the reasons that he identified in relation to climate litigation, but it's also hugely significant because it represents an evolution of the climate change regime. Because if you look at the Paris Agreement, in Article 2 of the Paris Agreement, it privileges a range of well below 2 degrees centigrade to 1.5 degrees centigrade. And 1.5 degrees centigrade at the time was seen very much at the aspirational end of that spectrum. And the fact that the Glasgow Climate Pact, 6 years down the line from 2015, has actually endorsed 1.5 degrees centigrade in response to developments post the 2018 special report from the IPCC suggests that this is a very dynamic regime that is evolving in light of scientific input. So that's also hugely reassuring. Of course, there are other challenges with the regime, but this is not the moment for them. I will sort of move on to talking about this paper that I did with the fabulous team at New Climate, Louise Jeffrey, Nicholas Honey, and others. And Dennis has already referred to work that they've done. This is a somewhat unusual paper because you have an international climate change lawyer, and I'm very much one-trick sort of pony, one-string banjo, as it were, but with climate change modelers. So it's sort of, truly interdisciplinary paper, and we learned a lot in the process. What we tried to do is to actually answer the question that Dennis has been posing: how do we actually, and this is the big picture question, how do we arrive at each state's fair share in mitigating climate change? So very simple question, but there are lots of different ways of sort of addressing it. And what we tried to do here is to start from an international environmental law sort of lens. And the context for this question, of course, is Dennis has already provided to some extent, but nationally determined contributions from states under the Paris Agreement are just fundamentally inadequate. We're not going to get to 1.5 degrees centigrade with current commitments, current NDCs. There's a lot of emphasis on target setting, but implementation is still a question mark. And even with the targets that we currently have, which we don't necessarily know will be implemented because the finance and support for it isn't necessarily in place, even those targets are inadequate. So when we look at that context, we see that states are required to justify in narrative form how their contributions are fair, how their contributions are ambitious and represent the highest possible ambition, and how they represent a progression from their previous nationally determined contribution. And in the NDC, states rely on numerous objective indicators to justify this. Now, these objective indicators are, of course, objectively selected and are often self-serving in the narrative that they put forward to sort of demonstrate that their fair shares are actually fair. So what we did was to look at these NDCs, look at the principles that states actually referred to in their NDCs. We look at these indicators and look to see which of these indicators are actually compatible with principles of international environmental law that states themselves endorse repeatedly in multiple fora. And we then arrive at a determination of fair shares within the principled framework of international environmental law. And I'll run you through the steps of this of this research method in a minute. The relevance of this is also something Dennis has already spoken to, but to the extent that we can find fair shares that are consistent with principles of international environmental law, they offer a benchmark for actually assessing the adequacy of nationally determined contributions. And once we have that kind of benchmark, we can also make peer-to-peer comparisons of NDCs across states. It helps inform litigation that Dennis has already alluded to, and it can also feed into the global stock take, which is ongoing. So let me take you through the research method that we followed. I'm not going to go so much into the sort of technical details of the modeling, not least because I'm not sort of qualified to talk to those issues. I'll talk more to the international environmental law issues. But the method that we followed was to review all the NDCs that have been submitted until March 2021. And we painstakingly went through all the NDCs to look at any references states had made to principles of international environmental law. And I'll come in a minute to the kind of principles I have in mind. and we looked at whether these principles were explicitly referred to or just implicitly referred to. We looked at objective indicators through which these principles are operationalized and the indicators that states themselves have put in their NDCs to justify their contributions as fair and ambitious. We looked at references to progression, highest possible ambition, and best available science, all normative pillars as we characterize them, of the Paris Agreement. We looked at and tabulated and calculated the number of references there were to the long-term temperature goal, sort of repeated endorsement of the temperature target. We looked at references to human rights. We then tested all the indicators that states had put in their NDCs against the principles of international environmental law. We did a sort of doctrinal analysis of these principles to see what the composition was, what their legal status was, what their operational significance is, and then tested indicators that states had put in against these principles. And we, I think perhaps significantly for this purposes of this analysis, identified indicators that are not part or anchored in international environmental law. So states are often using indicators, and I'll give you examples of those in a minute, that actually find no basis in international environmental law and probably are sort of at odds with principles of international environmental law. We then excluded those indicators in sort of the quantitative analysis of how we arrive at fair shares. But even with that, the fair share range, with principles of international environmental law taken into account, is still wide enough that at one end of the spectrum, at the higher end of that spectrum of fair share ranges, we still wouldn't make it to 1.5 or even well below 2 degrees centigrade. So we further compressed the range using further principles of international environmental law, such as prevention and precaution and the normative pillars of the Paris Agreement, to then find a fair share range that's actually compatible with the temperature target, with the principles of prevention and precaution, and is likely to lead to a climate stable world. So the kind of, to take you into some of the details of this research paper that we did, the principles that we analyzed and looked at, and we looked at references to these in the NDCs, were principles such as sustainable development, special circumstances, common but differentiated responsibilities, equity, harm prevention, and others. Now, these are all principles, you can write a book about each of these. They're differing legal status to each of these principles. The core content varies. The operational significance is different in different regimes. But for our purposes, what we did was to divide these principles into principles that are relevant to determining fair shares, such as, for instance, CBDR, or common but differentiated responsibilities, and equity, and special circumstances and sustainable development, principles that are relevant in interpreting fair shares. So they're not directly relevant to actually determining what fair shares are, because they're not equity-based principles, but they are principles that are relevant to determining how we interpret these fair shares, and those are principles of precaution and harm prevention. And then there are principles that are relevant in implementation. So they don't actually play a role in determining what a fair share is. So international cooperation, for instance, irrespective of how we do international cooperation, there's a fair share that's out there, and fair shares, in implementing fair shares, we can rely on international cooperation, but not in terms of determining what the fair share is. So good faith international cooperation and public participation are relevant principles, but principles relevant to implementation of fair shares. So this broadly is the kind of is a mapping of the kind of sort of data we mined. References here. So for instance, the principle of common but differentiated responsibility was referred to by 56 NDCs explicitly, in 17 NDCs implicitly. The references, for instance, to indicators like GDP per capita, there were about 27 of them. References to the fact that that a state was classified as small island developing state, or LDCs, 59 states referred to them. So this is sort of, just to give you an impression of how we actually went about doing this. So what's relevant for our purposes, is that we identified indicators that don't fit within the framework of international environmental law. For instance, share of global emissions. About 110 states actually said, well, our NDC is fair because our share of the global emissions is really small. Now, if 110 states say that actually, and if you add them all up, it adds up to more than a third of global emissions. So that's obviously irrelevant as far as sort of determining fair share is concerned. And this is an argument that has been raised in some cases in national courts. So the Rocky Hill mining decision, for instance, and judges have thrown it out and said, no, that is illogical. It's illogical to claim that you represent a small share of the global emissions, so whatever you do is fair. Whatever contribution you make is fair. So those kinds of indicators we found actually not in keeping with principles of international environmental law. So, for instance, the idea of grandfathering, that we are at that our current emission levels are so high that whatever reductions we make is a fair share of is our fair share. Now that's actually privileging sort of wrongful behavior in a sense. So that's obviously not in keeping with principles of international environmental law. So those are the kinds of indicators that we excluded. And in excluding those, we came to a sort of exclude those indicators and then arrived at a quantitative range of fair shares for states. But as I said earlier, even that range was well above, especially the top end of that range. If every state did the top end of that range, we would still not be in keeping with 1.5 degree, well below 2 degrees. So we then applied the principles of harm prevention and precaution and the normative pillars of the climate change regime. As I said, many states actually refer to these in their NDCs. 117 NDCs refer to these, therefore further endorsing and giving heft to the temperature target, the expectation of progression, highest possible ambition. And we then further narrowed the range of fair shares so as to bridge the gap between what states are doing, what states' fair share is the full range, to a range where actually states will be in keeping with their with the temperature target that has now been further sort of underscored in the Glasgow Climate Pact. So we then arrived at a range which was far narrower. So the what you see here is sort of an assessment of this, for G20 states. But if you look at the paper, it actually has results for all states that we looked at. And essentially, what we found is that for all developed states, they have a Paris temperature goal compatible emission level in 2030 that is actually net negative. Of the G20 states, only India and Indonesia can actually temporarily increase their emissions relative to 2010, and only India relative to today. And actually, half of the G20 states have actually increased emissions over the 2010s, and those that have decreased emissions have done far too slowly. So this is just a sort of impression of the kinds of results we arrived at. And if you have questions about the modeling, I'm not the person to address them to. They're my co-authors. But the point I'm trying to make here, and I'll end at this, is that the fair share range that we arrived at here is one that is compatible with the temperature target and is compatible with principles of international environmental law that states themselves have endorsed in their NDCs. And that offers us a benchmark. That offers us a benchmark to assess the adequacy of NDCs, which obviously feeds into climate litigation, and they can also sort of feed into the global stock taking exercise that's currently underway. So I'm going to leave it at that, but I'm of course happy to take questions, except on the modeling part of it, as I've indicated. But perhaps Dennis can pick up on some of the modeling questions. Thank you.
Thank you very much, Lavanya. Lucy, you can go next.
Thank you, and thanks for having me here. It's a great, really great pleasure to be here, speaking together with Lavanya and of course also with Dennis. That we know each other for some years now. Dennis and the Climate Litigation Network have been great supporters of our action here. I am from the organization ASUD, and my organization is the first plaintiff in the Italian climate litigation against the Italian state. I would like to take up a bit the discussion from the point where Lavanya just finished, which is the adequacy of NDC. And in our case, as member of the European Union, we don't have a national NDC by itself, but we have climate policy. So the adequacy of our Italian climate policies and why we came up with a climate litigation and why did we need an expert report that was based on a fair share analysis. So first, to take into account, Italy's economy is the 8th largest in the world. We are the 4th largest economy in Europe. So we are supposedly to be among those who are leading the path, who can promote the highest ambition in terms of emission reduction and climate policies. Notwithstanding this, at the national level, we can witness a slow decrease, a too slow decrease in terms of emissions. And if we look at the consolidated data of emission in 2018, we were at 17% of reduction of our emission in respect to the levels of 1990. So that was very, very poor, and it is still insufficient. On the contrary of the other European large economy like France, Germany, or the UK, we have no national legislated reduction target. We do not have a carbon budget, which is recognized by law, and we usually refer to what are the European targets. We have no national climate law, so we do not have a law we can use or specific targets, national spending, that on the contrary to the Agenda case or the New Buyer case in Germany, that we can use to assess its adequacy and its legally binding targets. So that's why, first of all, we needed an expert report. So to assess what is Italy's current and planned policies, and identify what would be, of course, the adequate emission reduction target that we would wish for our country in order to fulfill, in particular, with its responsibilities in terms of common but differentiated responsibilities. To do that, we had been lucky enough to have support from Climate Analytics. Climate Analytics is an independent research center, which provide one of the most cutting-edge scientific analysis on climate policies. It's part of the Pact, Climate Action Tracker model. So it's a model that analyzes countries' climate action to limit global warming and assess how much this is responding to what is expected under the Paris Agreement. So what has been done with this report, which supported the scientific ground of our climate litigation against the states, is what are the policies? So the first work that Climate Analytics did for us is to evaluate the current policies and the planned policies to see how much we would go with it. So very straightforward, Italian current policies would lead us to a reduction of 26% of emission reduction regarding the level of 1990s in 2030. And if we look at the planned policies, so the policies that are within the national energy and climate plan that we submit to the European Union, that would lead us, if they were implemented, because we are still far from implementation, to an emission reduction of 36% by 2030 with respect to the emission level of 1990. So this leads us to two types of consideration. Italy is below the average of national trends in the European Union, and Italy is far below the new European goal that was set by Fit for 55. No, so even if we implemented our policies, we still have a gap of 20%. But of course, this was just a first step in assessing with scientific basis of what our country is doing and its insufficiency. It was very important also for us to understand how adequate and which kind of target we would like our country to direct itself towards. So that's why we have went through a perception of the fair share. Why a fair share? As I said, we have no legislated update emission reduction target, and we needed to enforce our legal demands in this regard. So that was very important for that. But we also needed to set an adequate emission reduction, and we did that using the fair share method. climate analytics report, so the developer report for our climate litigation. This report was developed a little bit earlier with respect to Rajmani and all paper. There is some common authors, so let's say that it's a similar approach to the question of fair share. And what did climate analytics in these reports? It of course take its global methodology to look at fair share. So it looks at different level of liabilities and various equity approach. Could be emission per capita, historic emission capabilities, so on and so forth. And it tried to gather that. To show you a bit and to retake some points that Dennis raised regarding the fact that the various literature in the equity approach could lead to some wrong destination. The effort that the climate analytics methodology try to bring forward is to see how we could avoid the fact that if each country choose a methodology that is the most easier for them to implement, that means like allowing them to emit more, this would lead us to go over the emission budget we have. So I will briefly share some image from the report. Okay, so here this is just briefly, can you see correctly? Yeah, you can see briefly the evaluation they made of our current policies, which are the blue one, and you see we are right on the top of the red area of fair share, and the plan policy is the blue line. But what I wanted to illustrate a bit to explain in simple terms what is the effort of trying to have this median range of fair share. They developed this kind of figure to explain what are the limits of the various and single approach on equity that could lead to inappropriate policies. So, and this is a very interesting report, I think, even if it's based on Italian purposes, because it's aimed to explain a judge who doesn't know anything about equity or climate change science, what we are talking about. So in this graph, in this figure, you can imagine a world where there would be three countries, would be China, United Kingdom, and Gambia. And for in this world of three countries, there will be, let's say, a target, an emission budget of a number of eight clouds in these cases. So if we look, for example, at the distribution equal per capita emission, we would see that China is allowed to emit more because it has more inhabitants, and Gambia can emit less because it has a lower population. If we look in terms of historic responsibility, in that case, for example, you would see that United Kingdom is not allowed to emit anymore because they have more historical responsibilities in terms of emission. And if we look at capability, let's say that the distribution is more distributed. But what is interesting to look at is that if you look at the upper range, so where the countries can emit more, and if each country can choose its equity method that is more appropriate, more easy for them to implement, so where they would have to decrease less their emission, we would arrive to an upper range of emission would be over the budget that was initially set. So where we had a budget of 8, if everyone would choose what fit them more easier, we would go over our budget. And this is tendentially what is happening. And on the contrary, going into the lower range, so trying to push for the more ambitious measure, we would arrive here on a very, very small emission level. So this is a brief, sorry, I will close it down, just a brief explanation about why in particular it's important to have not a single view, but combining the different technique and see how we can come to a median range that would enable to get from the national ground at an international level, a distribution of the fair share that would really allow us not to go above temperature goal that was being set by the Paris Agreement. This, of course, leads the CAP methodology to look and identify combining the existing sharing effort and equity approaches, which of course is based and include the IPCC equity consideration, to look at what would be the base case, the worst case, and the medium case scenario. And they developed for the purpose of the report a graph, of course, for the global level, but they also declined and explained the same kind of reasoning for Italy. And this is another interesting image to look on. You could see here on the basis of their methodology and the calculation they made, you could see the worst case scenario. So if every country should have the fair share methodology, which is more easier for them to apply, that would lead us to, in terms of gigaton for CO2 equivalent of emission, the best case scenario and the medium, which can inform, let's say, the direction to be taken to get an average, a medium action that would guarantee still to remain well below 2 degrees temperature. And the same methodology they applied at the national level in order to calculate what would be Italy's fair share. And we have here again what would be the worst scenario of application of fair share for Italy, the best scenario, and the medium range on which they basis, on which we based our demand, basically. So what have been the results for Italy? And this is the first graph I show you. So this is what they come up with in terms of calculation, is that if Italy wanted to respect fair share to reduce its emission, we would need to reduce Italians' emission by 92% by 2030. That's a very high target. Of course, this is not something that in particular decision makers in Italy are used to confront with, but that would be basically what we would need, globally speaking, that our country do to contribute really to what is its historical responsibility and also what is its capacity today to act towards climate change. Which was very useful also, is that all the calculation that climate analytics developed for our case, they also not only aimed a target, an emission target that respect fair share up to a certain ambitious level, but they also calculate what would be the carbon emission budget for Italy, because as I stated before, we do not have a nationally recognized carbon budget, so it's a bit complicated to develop policies that are really planned and based on informed science of what our country should do. And under the calculation from 2020 and 2030, we would have a carbon budget of 2.1 gigaton of CO2 equivalent. Saying in a more comprehensible terms, that would mean that if Italy continue to emit as we did in 2018 in particular, we would have already finished our carbon budget by 2025. So this is, let's say, the picture. But what are this fair share, and to have some final reflection on our specific case and the use of fair share that we had in this litigation. Some implication that it has. So of course, our case is a strategic litigation. It's based on the recognition of the violation of human rights related to climate change. So our first legal demand is to recognize the responsibility of our state to guarantee climate stability, to protect the population from further human rights violation in the future. The second legal demands that we go is completely based on the fair share approach, and we require the judge to express itself and to ask the state to reduce its emission by 92% in 2030. And we include, of course, in order not to risk to be completely, to have a strong reaction from the judge, not recognizing the admissibility of this question, we added or other greater or lower amount, as it may be determined in the course of the proceeding. And it's very important here to have a scientific report which explains the methodology, which explains the background on which it is based, to provide the judge with the capability to understand what the international law sphere as well as the climate modeling science is saying in terms of emission reduction, so that the judge can have the tools that even us, the practitioner at national level, and the decision maker did not had until now, until we did have this kind of investigation and research and scientific data available, developed for this climate litigation. So Finally, just a few remarks on the difficulties of this number from a campaigner perspective. I am not a lawyer, I am not a scientist, I am an activist from an organization, and I work on climate justice as a core action of our organization. We are rooted ourselves in what has been the history of the environmental and climate justice movement. So for us as an organization, was very important to underline through a climate litigation the responsibilities that the global north, and in this case, our country, had in regards with the global south. So it was completely adherent to our ideals and our mission to go for a fair share demand, even if we are well aware that on the legal ground, in particular in court in Italy, where this kind of legal advancement are not very well spread, let's say it like this, that was a big ambition from our end, but it was very important from a political perspective, or a political point of view as a plaintiff in this demand. And of course, with regard with the work of advocacy that the social movements in Italy are doing towards the decision maker regarding climate policy, that also tools to show to what extent, if we look at the reality of the facts of the responsibility of what science say, what should do the Italian state, because this kind of higher level of ambition is so far from the political debate in this country that it needed to have strong scientific roots to be able to show our decision maker that when they think, oh my God, how can I get to the 55% emission reduction that the European Union states, that we are far from this, that we would need to think in terms of how do I get to a 92% emission reduction and not just a 55% emission reduction. So that's also something which is this kind of report and scientific cooperation between the scientific field and the legal field in our work as advocates, quite fundamental. And to conclude with, of course, the main challenge we have right now, if we look in particular to the fair share issue, is getting into the media attention and get to the public audience. And we are still quite far from it because it's very complicated yet in Italy to have, let's say, mainstream media to look at what are the question of liabilities behind climate change, state responsibilities, companies' responsibilities. So our work through the climate litigation is also to push for that. And hopefully, as we noticed that for the hearings, we have much more attention than we have a number of time on campaign. We hope that from the moment where the judge will enter into the technical details and the scientific data of our research, we will be also able to talk about the international dimension that national policies in Italy have and how much our country still need to have a long way to go to face climate change and to contribute at international level as it should be, being among the main economies in this world. And I will stop here now.
Thank you very much, Lucy. Thank you. These are really excellent presentations. We have 3 excellent questions here. The first one is, what could be the implications of these fair share figures on defining the scope of states' mitigation obligation under customary international law rather than the Paris Agreement? So fair share figure in interpreting states' due diligence obligation under customary international law and thus limiting the scope of states' discretion in setting mitigation goal.
Should I take that?
I think so.
Hey, thank you. No, that's an excellent question. The other 2 questions are also excellent, actually. So it's going to trigger a really interesting discussion amongst the panelists. But on sort of fair share and its relevance to customary international law, the harm prevention principle, as I'm sure the sort of author of that question knows, is not an obligation of, doesn't entail an obligation of result. It's an obligation of conduct. So obviously it's a best efforts obligation that states have. And one of the challenges is defining and constructing a standard for due diligence, a standard of care for due diligence for states. And there are many factors that go into constructing that standard of due diligence. And there is interplay between customary international law and treaty law in constructing that standard of due diligence. And I think fair share analysis will certainly go some way in helping to construct that standard of due diligence. So each state's fair share is a relevant factor in determining the standard of due diligence in relation to customary international law, which then will have an impact on limiting a state's discretion, as the author of that question sort of notes. I should say that there are other factors as well relevant to determining the standard of due diligence, and some of those factors will be regime specific, so we'll draw from the climate change regime as well, even though it is customary international law. As I said, there's interplay between treaty law and customary international law here. So for instance, the evolution in the regime towards 1.5 and a reiteration of the 1.5 degrees end of the spectrum is something that will play a role in determining the standard of due diligence required of states, because if you look at the ILA principles on these issues, or the ILA's report on due diligence, you see that the nature and extent of consequences if due diligence is not exercised is a relevant factor in determining the standard of care. And now with repeated sort of IPCC reports, we know what the consequences are going to be: serious, pervasive, and irreversible. So that is also a relevant factor in determining the standard of due diligence. And so, yes, fair share will certainly play a role in determining that standard of due diligence, but it does also lead to some complexities, because it might be that states need to do more than their fair share, given the existential threats that we are being faced with because of 1.5 degrees and not being on track to that. So it does pose some complexities as well, but it's a very interesting question. It's an interesting area for explore further.
Yeah, if I may add some thoughts to that, is that especially with regards to the standard of due diligence, that was actually also applied by the Dutch Supreme Court, in the way that they said, well, under this standard of due diligence, there can, under circumstances, there can be an obligation on the state to justify that what it's doing is enough. And most countries aren't. They're just saying, well, this is our target because that's what we can achieve, and there's no underlying assessment. And the idea of fair share is not only, and the importance of that is not only rooted in international law, but also in international politics. I mean, if you look at social science, they say, well, there's no way that all the individual efforts, even if they're individually established, can add up to the result that we need to be, if those individual efforts are not collectively seen as being fair, are not perceived as being fair. So it's more. So in order for any effort to be sufficient, it can only be assessed in relation to this idea of fair share, which climate scientists have modeled. So under this due diligence standard, at least in the way that also the Dutch Supreme Court interpreted it, and that's now also something that you're seeing in other cases, especially in countries that don't have any assessment with regards to what they need to be doing. The duty is on the state to come up with an explanation of what they're doing, whether it is sufficient. And that already is an enormous step, because that assessment is not there. And once states make that assessment, they will have to base it on something. It will have to be grounded in science, in the budget, in some reasonable and not deranged way of divvying up the pie of the remaining budget. So in another way, there these fair share analysis become very important, not as the primal standard, but as the only method and tool in which states can fulfill the due diligence obligation of making the assessment in the first place. And I think that that's going to be also important in many cases.
Thank you so much. The second question is, what role, if any, can fair share figures play in establishing states' extraterritorial human rights obligations in the context of climate change?
Well, I think this is also a very interesting question, and I can only answer part of it. I'm afraid, but that actually goes to the methodology of these fair share analysis that Lavanya and Lucy have set out, because the scientific methodologies look at responsibility with regards to reductions, but not the geographical location of those reductions. So the methodologies do not say those reductions need to take place within within Italy, for instance. They just say this is the amount of reductions that need to take place. So to the extent, I mean, sort of from a legal perspective, to the extent that Italy says that it's not able, due to feasibility considerations, for instance, to reduce to 92% within the territory of Italy, they can actually, reduce those emissions abroad. And if you look deeper into sort of the global governance framework thinking, you can say, that lies behind these modeling efforts, is that that's actually the framework within these models have been set up, and that is the countries should at the minimum do what is according to cost efficiency models within their own territory. And for global north countries, that means that they need to do more than that with regards to their fair share. And ideally, that would be done via international finance. So by supporting global south countries with their reductions. That is still, and you can also see that framework in the climate action tracker, where they differentiate between cost efficiency, what they call the domestic target, which is kind of like, what does the global cost efficiency trajectory tell us, and a fair share target, where they say, well, the difference ideally would actually be done through via international finance. So that's kind of like a link between those obligations and these fair share models.
I mean, I can just quickly add to that very different dimension. I think, again, it's a fabulous question. I think a very different dimension to this might be in terms of what a state has within its jurisdiction and control in terms of climate activities and the harm that's emanating from its jurisdiction, and the extent to which those harms are actually affecting human rights, progressive realization, or sort of impacting human rights of those beyond their borders, is what I understood the question to ask. And certainly, I think in making that assessment, whether, again, the question of due diligence will come into play. And I know due diligence has sort of different connotation in the human rights field as compared to the international environmental law sort of scholarship. But in determining due diligence in that context, then fair share of states, at least from international environmental law perspective, would be relevant. Whether a state is sort of exercising due diligence and ensuring that activities within its jurisdiction and control are not impinging on the rights of those that are beyond its borders. And I know the Inter-American Court on Human Rights and the sort of advisory opinion that came out some years ago sort of had a very positive, progressive sort of stance on extraterritorial human rights obligations in relation to climate change harms.
Very briefly, another input that came to my mind regarding this question is in particular looking at Italy and in countries where you have companies, corporations that are partly state-owned. So it's the case in Italy. In Italy, we have our main fossil fuel energy company, Eni, which is a third owned by the state. So of course, when we think about such a high level of emission reduction, you have to think it also how you reduce it outside of the domestic territory. And the first step would be also to go to review all these companies' own states first, and of course, based on in your territory, to see how much they contribute abroad to emission and how this can consist in a violation of the human rights of the people that live in the country where they operate. And it's definitely a potential future path that would be very, very well received.
I know we're almost out of time, and I know that Lavanya, you may need to go, but maybe we have just a few minutes to answer this last question, which is also a great question, which is, what is the legal basis for being able to challenge a government's fair share target? Is it because the state has signed up to the Paris Agreement? For dualist countries like Australia that we have not legislated the Paris Agreement at a national level, would it not be possible to bring a fair share demand against the government?
Dennis, do you want to lead on this?
I can have a step of that. The way that it's dealt with in different countries is very different, and one of the factors definitely is the integration of international law into the national legislative sphere. The Netherlands, as an example, is very much of a monist country where international law is very much integrated into the domestic legal order, and then you can more directly draw upon these international law principles. If you, for instance, compare that to Australia, and I happen to know also a little bit about the Australian context because we've been supporting a case there that has been filed by two people living on the Torres Strait Islands. I think a very good way of, and in that case, basically what I was just outlining, the ask in that case basically is, well, the government hasn't made any assessment of what is sufficient. And this question of sufficiency can only be answered in relation to the efforts of others. So even without directly referring to these international law principles, which are the main source of these fair share analyses, you come to a very similar, if not exactly the same analysis. And to make that very concrete, for instance, in Australia, the Climate Change Authority in 2014 came out with a report which identified the global carbon budget and then looked at what should be the Australian carbon budget. And it did that on the basis of fair share principles. It looked at the different interpretation of fair shares, and it actually took a fairly conservative interpretation of the different principles as the principle to then inform the Australian budget. And it didn't do that in relation to the international law principles, but as to, well, no effort can be sufficient if it's not fair in relation to, unreasonable in relation to other efforts. And that was then, and that calculation actually feeded into informing some of the different state targets, because although this assessment is not made at the national level in Australia, for instance, the state of Victoria has made this assessment, and there was an independent commission that advised on what the 2030 target for Victoria should be, and the legal sort of requirement with regard to that target for 2030 that was relevant was environmental sufficiency. Right? And the independent advisory panel said, well, no target can be environmentally sufficient if it's not in relation to fair share principles, because otherwise it can't add up at the global level. So there you see an entirely non-international law principle being used and getting to the same result. And in fact, the Victoria 2030 target is based on such a fair share analysis that was previously done by the Climate Change Authority already in 2014.
That was quite a comprehensive answer, actually. Then, if I could just add a few lines on the sort of Paris Agreement part of it, I would say that, given the nature of the Paris Agreement, which essentially does not contain an adequacy function within it, at the international level, to see that, to check whether states are doing enough in a sense, and certainly doesn't have any equity review function either, which seeing whether each state is doing its fair share. And at some level, all it requires states to do is to produce these NDCs and provide a narrative justification for whether they're fair and ambitious and represent, progression. Given that context, actually, just purely implementing the Paris Agreement in domestic, in sort of national and domestic contexts is not going to give you sufficient hook, in a sense, to say, well, this does not comply with the Paris Agreement, because actually it would comply with the Paris Agreement because it's mostly just procedural in some respects, right? So I think you'd have to have something more to hook on to it as far as the Paris Agreement is concerned. And one way in which the Paris Agreement has been very productively used is in relation to Article 2 and the temperature target, to use that to interpret what the carbon budget should be, and therefore what the fair shares of states should be. Because as Dennis is saying, if a litigant comes to a court and says, well, what we're doing, whatever we've promised to do at the international level is not sufficient, then the court's automatically going to ask, but how do you determine sufficiency? How do you determine whether it's adequate in the context of a global collective action problem? And it's in that context that you start looking at, what is each state's fair share? So that question will crop up independently of the international regime anyway. It's a sort of global collective action problem. What the international regime does do is offer a hook for providing a carbon budget, in a sense, based on 1.5 now, or well below 2 degrees centigrade at least, rather than 2.5 or whatever else. So there's sort of a global direction of travel that the Paris Agreement has sort of established, which helps set the context for many of these fair share discussions. It doesn't actually prescribe particular fair shares, obviously, or prescribe particular benchmarks for determining fair shares. Thank you.
Wonderful. Thank you very much. I think we're done with the questions, and I don't want to take much more of your time, but I really, really appreciate you coming here and sharing a little bit of that topic, which, you can see that we could talk hours about this. So there's definitely still a lot to discuss, but I really appreciate it. If you can share your slides, a lot of people asked about them, so we can put them on the events webpage. And I also added the link to the Sabin Center's network of peer-reviewed scholars, which has the events at the bottom. So we have all of the events that we have done, and with the links to the videos, and this one will also be shared there. So thank you very much, Dennis, Lucy, and Lavanya, and I really appreciate you coming here. Thank you for all the people who joined as well, and we'll see you all soon. Have a great day.
Thank you. Thank you all for coming, and thank you for inviting us, Maria Antonia. Thank you. Bye.
Thank you. That was a great pleasure. Bye.
Bye-bye.
Bye.